SJC-12649, Commonwealth versus Dax Gibson.
Okay, Attorney O'Brien.
Good morning, Your Honor. It's Jennifer O'Brien for the defendant on appeal, Dax Gibson. If you think of this trial as a card game, here the defendant's attorney was holding an ace the whole time, and he didn't play it, not because he didn't think he needed it, not because he had better hands to play, but because he didn't know that he was holding it. And this ace in the hole that I'm talking about, this card, is the 12:16 phone call from Dax Gibson's apartment to Dee, the other person, the co-defendant in this case. Now, this case was very much tried as if the shooting occurred anywhere between 12 and 12:45. The Commonwealth concedes this in their closing argument, says that the reasonable inference was that this time, the shooting occurred between 12:30 and 12:45, they say. And they acknowledge Amanda Compton, who testifies that the crime occurred at 12 noon.
If I could ask you on the timeline, just putting aside for the moment, because I get your point that it's a landline, but put aside for the moment, there might be all sorts of strategic reasons we are really close to the time of the murder. You don't want to put in evidence that alleged joint venturers are in communication. But let's just put that aside for the moment. The timeline is, I guess this would be an understatement, fluid here at trial. You've got the neighbor, Lakesonen, saying 12:46 he sees the vehicle across the street. You've got Fillinger saying that the defendant and Brown arrived at her apartment 1 to 1:30. You've got the victim's girlfriend, Mejia, talking about not knowing where the victim was at 1:20. And so you've got the deceased, the alleged victim, found at 2:12. I certainly understand the other times that you just explained, and,
Yes.
and I have them in the timeline. So the question is, putting aside that whether it's strategic not to put this evidence in,
Yes.
isn't the timeline so amorphous and mushy that it's hard to say that this is going to create a substantial likelihood?
I don't believe it is, Your Honor. I mean, there are two timelines, I think, essentially. There's Cindy Mejia and there's Amanda Compton, the neighbor, and they both said that this occurred at noon. Amanda Compton actually looks at a clock. She's the only individual who looks at a clock. And to clarify, she didn't hear gunshots. She heard loud bangs that were loud enough to make her toddler, I think it was 3 years old, begin to cry. And she heard wrestling, and she heard people running down the stairs that sounded like a herd of elephants. So that is exactly at 12. And then you have Cindy, who was awake at the time, actually. Someone had come to the door at 10:30, presumably to buy drugs off of the victim. And she testified that it occurred around noon. She had somewhere to be, actually, at 12 o'clock. They were going to go to her mother's or something. So that's one timeline, so to speak. The second is that this could have happened between 12:30 and 12:45, which Gary, the neighbor, says it ended around 12:46. He sees them take off. And Tiffany states that it was between 1 and 1:30 that they showed up. And if it was 1 o'clock, that fits the timeline that we're arguing here. It fits Gary's timeline because they immediately went to Mechanic Street, which was Tiffany's residence, but they did some cleanup. They threw
that helps, I understand, but she just didn't say 1 o'clock. She said 1
She
to
said
1:30.
1 to 1:30, yes.
1 to 1:30. So that's sort of my point, is that it's hard to nail down a timeline in this case.
Well, even if it was 1:15 that they showed up, there was no testimony as to how long it took to to clean everything up. I mean, they got rid of the gun, there was blood on the back seat, they used napkins to wipe it up, and a T-shirt, they threw the napkins and the T-shirt away. There was a conversation in the stairway where Mr. Gibson was saying Michelle's a witness, and they discussed her not talking to anyone. All this happened before they show up at Tiffany's apartment. So I think it's important, the people who actually saw part of this crime or heard part of this crime were Amanda Compton, Cindy Mejia, and Gary, the neighbor. Those three individuals, if one is to believe any one of those individuals, make it impossible for Mr. Gibson to have committed the crime.
All right. Can I ask you, just make sure I understand the factual predicate here?
Yes.
When the perpetrator comes to the door, is there just one assault? Is there just one victim and one assault?
Yes.
Okay. And the predicate felonies for felony murder, is my memory right that it's armed assault in the dwelling and home invasion?
Yes.
So if there's only one assault for the predicate felonies, why isn't there a merger problem for the Commonwealth?
Well, there is, and I did argue that, and I think the Commonwealth conceded that. I think
No, that's a merger problem. That's not a merger problem. That's just that one of the felonies goes away because it's the predicate.
Oh,
That's
the
a sentencing
predicate felony.
issue.
Oh, okay. I think, well, there should be, Your Honor. And I think it's the Donahue case. There should be a problem with. I think you're right on the money. I don't know that I argued that, but I argued instead that it was duplicative on the third argument that I made. Mm-hmm. But yes, there should be an argument with that. You know, I think.
So what happens? There's a. Those are the only two factual predicates for the felony murder, right?
Yes.
Okay.
Yes.
All right.
So I think it's important to note that, you know, Michelle Kelly says that this occurred in the middle of the day, and that the whole thing happened between 12 and 2. I think it's important to, her testimony is not that the shooting occurred between 12 and 2, that the whole thing, by the time they go to pick him up, is between 12 and 2. So it was argued by defense counsel in his closing argument. He asked the jury to consider the timeline in the case. It's undisputed that the crime occurred at 12 noon. You heard that from Cindy. If you freeze time, where is Dax Gibson? He's at 365 Elm Street in Gardner. Alicia testified that it's a 20 to 35 minute ride from Gardner to Fitchburg, and Michelle testified that it's a 20-minute ride. Even if it's only a 20-minute ride, it gives him approximately 9 minutes to commit the crime. That's if he was in the car at the same time that he hung up the phone.
Rather than asking you to recollect a complicated legal doctrine like merger in Commonwealth versus Gunther on the fly, would you like an opportunity to file a supplemental memorandum?
With respect to that,
supplemental briefing
yes.
with respect to merger?
Thank you. I appreciate that.
Okay.
So, and again, the first argument is he was armed with this 1216 call. He didn't know about it. I don't know why the Commonwealth is stating in the brief that it's their brief that it's a tactical decision. It was reasonable. It wasn't tactical at all. I think he's clear that, you know, he states that if there was a phone records that supported the defendant's case, it was an oversight. It wasn't a tactical decision not to use them. With respect to the phone calls from Michelle Kelly, I concede that certainly if that was the only issue here, that she testified repeatedly that she wasn't allowed to use her phone, and there was evidence that she did use her phone, that isn't sufficient to give the defendant a new trial. But when you take that in combination with the other arguments with the phone records, I think that there is. With respect to the third issue with the phone records, the the time that it's silent, Dee's phone. He uses his phone, there's 18 pages of phone records for a 24-hour period. He's literally on the phone every minute of the day. The biggest gap that he wasn't on the phone was this 21 minutes between 12:22 and 12:43. And I know the Commonwealth argues that he was not using his phone because he was waiting for Mr. Gibson to commit that crime. If the crime occurred between 12:22 and 12:43, that's perfect for the defendant because he couldn't have been there because he was making a call 20 to 35 minutes away at 12:16. So if...
How do we know that that was the defendant making that call?
Well, there was testimony from Alicia and Ashley that Mr. Gibson was on the phone before they left or before he left. There were multiple, Alicia testified that she didn't even know Dee. There was no one else in the house, which is why they had to take the child with them when they went to Fitchburg because Dax wasn't available to watch the child. So there was nobody else in the house. There was no testimony or evidence that anybody at that household other than Dax Gibson knew Dee. So by process of elimination, he was the only one who could have made the call. There was no testimony that anyone else was in the residence. And one of the witnesses, Ashley, testified that they actually left before Dax Gibson and that Dax Gibson was on the phone when she left, giving somebody directions. So, you know, there was testimony. If the Commonwealth argues that this is cumulative, there certainly was testimony by Ashley and Alicia that the defendant was at home at around noon or approximately thereafter, but there was no evidence that he was there at 12:16. And obviously you can see the defense counsel's predicament where he's arguing that you should believe Ashley and Alicia who testified that Dax was at the house around 12, but don't believe them when they say that Dax confessed to the crime to them. So obviously having a evidence that isn't subjected to a credibility problem would be key for the defendant.
Isn't there some evidence that Ashley didn't leave with the defendant?
Alicia testified that the defendant left before them. She said she got there at 12. The defendant was on the phone, and I think she said he left about 10 minutes later. Ashley testified, and I put this in my reply brief, the exact transcript portion of it, that she went downstairs and she was leaving and Dax was still on the phone. So she actually left before Dax, leaving him in the apartment alone. With respect to the 21-minute time frame where the D's phone is silent, I think the Commonwealth in their brief has also said that one can reasonably infer that the defendant and D weren't communicating, or he wasn't on the phone because him and the defendant were talking about this crime. There is testimony, this contradicts Michelle's testimony, and Michelle testifies, and this is volume 3-55, that while the defendant, Dax Gibson, was in the car and he and Dee were discussing this robbery, Dee was still using his phone, and that he was agitated and, I'm paraphrasing a little bit, but he was all amped up and mad about what the victim had done to him. So he was still using his phone while Dee was in the car. So that eliminates any argument that he wasn't using the phone because the defendant was in the car with him. And here, I think there's one other additional actually point that I wanted to make, which isn't in my brief. I was reading the transcripts again, and with the timeline, Michelle testifies that after they pick up the defendant, she believes that they probably, and this is volume 3, page 189, 190, they probably stopped for gas. There was testimony that Dee would pay her in $5 increments to get gas for driving him around, and that after this round trip, 40-minute ride, that she needed gas again, so they probably stopped for gas. So if that is true, and if the jurors believe that, that sets the timeline even more in favor of the defendant if he left after the 12:16 phone call, and this crime was committed by 12:46 p.m. I think, like I said, the Commonwealth has conceded to one of the arguments, and I think them conceding to that makes the second to the last argument moot. With respect to my second argument with the joint venture instruction, I know that I have the uphill battle here, obviously, with Zanetti. And hopefully you got my point in the argument. It's not so much that there wasn't proof of a joint venture. Certainly that's the way the Commonwealth tried this case. It was just that if they believed one witness, Cindy Mejia, and that the defendant wasn't there at all, that it allowed the jury to find the defendant guilty of something that wasn't supported by the evidence, and I don't think the law has changed with respect to that.
I think that's what Zanetti also said. We just look at sufficiency on these theories, correct?
Yes, yes. And here, the phone calls certainly made a difference. The evidence here was far from overwhelming. There was no, even though they said, Michelle testified that the defendant had blood all over the back seat of the car, there was none of his DNA. There was certainly evidence of a third-party culprit here. It could, there was a whiz that people testified that the defendant was introduced as. Whiz matched the description of that Gary said there was the person that was coming out of the house after the shooting had a hat on with dreadlocks or braids, and that's Whiz has that. The defendant here was bald. The witnesses were inconsistent. They were all over the place, certainly, and even the Commonwealth acknowledged that in their closing argument, that you have to just believe some of what they said because they conflicted with one another. They conflicted with themselves. Prior things they said, they were addicted to drugs. They had reason to blame the defendant and shield D from this because he was their drug supplier. And I know, again, the Commonwealth actually used the timeline in their closing argument to argue the extreme atrocity and cruelty, saying the best we can take from this evidence from Gary, 12:30, 12:45 when the incident occurs and people are running away, but medical doesn't get there till 12:14. And again, there was testimony that the victim was long deceased by 12:14.
2:14.
I'm sorry, 2:14. Thank you. The argument was that because the victim was laying there for almost 2 hours, that the golden hour to save him was lost, and that was something that was argued by the Commonwealth. So again, the Commonwealth and the defense attorney here argued this timeline. They were a little bit off. The defendant obviously was arguing that this occurred at 12 noon, but the Commonwealth was arguing it probably happened between 12:30 and 12:45. And that's the way that this case was tried. So to have these phone calls, the phone records into evidence was extremely important to the defendant's case. Unless there's any other questions, I'll rest in my brief. Thank you.
Thank you. Okay, Attorney Herron.
Good morning. May it please the court, Donna Marie Herron on behalf of the Commonwealth. I just want to quickly, although I'm not prepared for this, I want to direct the merger issue, this court to Commonwealth v. Fredette, which I believe this court did discuss the merger issue, and I'm not haven't read it in a while, but I did recently argue it in Commonwealth v. Connors in the appeals court, and it's the holding, I believe, and again, I haven't read it in a while, so if I misconstrue it, I apologize. I believe if there's sufficient evidence for the underlying felony, and here's it would be home invasion and armed assault in a dwelling, that there is no merger issue.
It depends on the felony. So some felonies, robberies, rape, we say there's no merger issue.
Okay.
Not so
I
much.
haven't read it in a
Yeah,
while, so I'll have to read.
That's why you shouldn't do this off the top of your
Yes.
head.
I just wanted to direct the court to that opinion. and I will-
It depends on the nature of the felony.
Yes, I will reread that when I get back to my office, but thank you very much. The motion judge here properly denied the defendant's motion for a new trial, where the defendant failed to establish that trial counsel rendered ineffective assistance, and I apologize, I have the wrong standard in my brief, or that the error created a substantial likelihood of a miscarriage of justice. I had the old standard under there, and I apologize in my brief. Here, trial counsel said in his affidavit that he had concerns about establishing the phone records and who made the phone calls, and I think that is one valid concern he had. Ashley testified in direct that the defendant left before her and Ms. Francis, Alicia, left. Ms. Francis testifies that the defendant left before them. On cross-examination, Ashley is cross-examined with her statement with the police, and then she acknowledges she told the police that she left before the defendant left. So there is conflicting testimony there as to who left first. I would suggest that he recognized that there would be an issue authenticating who made the telephone call and that what numbers belong to who. Granted that Ashley could testify that what her home phone number was, but there'd be no one to testify as to Mr. Brown's phone number.
I appreciate that there's testimony that Francis said that Ashley left first.
Yes, and
And that's helpful too, I understand. But as you put in your brief, basically, you have a comment in your brief about the problem here is not the law, the problem here is the facts, and that it's a very strong case for the Commonwealth. So this is, it might not be great evidence, but this is huge alibi evidence when there's not much to work with. So doesn't that augment the importance of the defendant putting this in?
I don't believe so, Your Honor, because the probative value, I don't think, was very overwhelming or underwhelming, given the nature of the timeline established at trial, as has been pointed out earlier. There was this definitely occurred at this time, so therefore that phone call would be pivoted, if he can even establish that the defendant is the one making that phone call.
And that's obviously a good point. I read that in your brief and mentioned it. It's a good point. But I think on the other hand, though, you get a neighbor who basically, if I'm remembering correctly, not only looks at the clock, but is comparing what she heard to a herd of elephants.
Yes.
And that time is around noon.
Around noon.
So again, putting this in context, it might not be much, but it's really the most probative evidence the defendant has consistent with his theory of the case.
I would disagree, Your Honor, particularly where Ms. Compton specifically asked, did you hit gunshots? And she says, no, I did not hear gunshots. What I heard was a herd of elephants coming down the stairs. We have Ms. Mejia, who says around noon, no one says specifically, it occurred specifically at this time. And then we have the neighbor, who I think is the more pivotal one, because he seemed very confident on his time, which is 12:46 p.m., that he sees, and it's very telling what he sees. He sees a blue car outside he calls it his neighbor's house. He sees a woman there, and he sees a male there who he describes, who I would suggest is similar to Mr. Brown, although he does not identify Mr. Brown. He then says he sees his neighbor running out of the house, and then he sees a second gentleman dressed in a black mask running into the car, and the car taking off. The phone call does not undermine that, because we heard testimony that it takes about 20 minutes to get to the house, and that is well within the time period to commit this murder. So the Commonwealth would suggest, given that there was a fluid time period and there's no precise timing of the murder, this phone call, the probative value, as the motion judge found, was not significant. And most importantly, a strong defense was put on for the defendant, and defense counsel strenuously argued, based on even Ms. Francis's and Ashley's testimony, that he couldn't have committed this because he leaned in that it was, Ms. Mejia said it occurred at noon, and he was still at the house in Gardner. So the strong alibi was argued to the jury, and they rejected it. But giving the overwhelming evidence of the defendant's guilt, which there was 5 witnesses who testified where either saw the defendant commit this crime or was in the car, or he confessed to. So there was overwhelming evidence of the defendant's guilt. So I would suggest, even if this court were to find that defense counsel should have put it in, it did not create a substantial likelihood of a miscarriage of justice. I would suggest the claim that impeaching Ms. Kelly with her cell phone records lacks merit because she was thoroughly impeached at trial. Defense counsel even called witnesses to try to impeach her. And as this court knows, failure to impeach does not constitute ineffective assistance per se. I also would suggest Mr. Brown's cell phone records. There was an obvious reason not to introduce it, which is it was a double-edged sword, as I think is what the motion judge found, and I think she was correct, because the Commonwealth would have argued he's with Mr. Gibson. That is why he's not using his cell phone. He's calling him, telling him, come outside, let's go, and then there's no phone calls, which would support the Commonwealth's theory that they're together at this point. So I think there was an obvious reason as to why defense counsel would not want to use that. Moving on to the second issue, this judge followed your directive in Commonwealth v. Zanetti to a T. He gave the model and jury instructions as this court has dictated, and he gave the general verdict, which this court in Zanetti said should be given. And there's no chance that the jury convicted the defendant on theory where there was no evidence. If the jury believed the defendant's theory, which was, I was not there, was not me, it had nothing to do with this, the jury would have come back with a not guilty verdict. The only verdict that the joint venture went to was that they were both there, and as the Commonwealth strenuously argued, the defendant was the shooter. So there is no risk that the jury came back with a verdict that wasn't supported by the evidence. As you noted, Justice Gaziano, this court will look to the sufficiency of the evidence to determine whether there was sufficient evidence, which I would suggest there was overwhelming evidence of the defendant's guilt here. And as this court in Zanetti outlined, the reason why it's no longer required for the Commonwealth to establish who's the shooter and principal or who's the accessory is because you're equally liable under the law. And so that's why this court found that, and I think it was Justice Gantz who wrote the decision, that the general verdict slip should be given in the jury instruction, which was given, that the Commonwealth has to prove beyond a reasonable doubt that the defendant knowingly participated in the commission of the crime, alone or with others, with the intent to commit the offense. That was the instruction given at jury. There was no error, and there is no reason to overturn Zanetti. If there's no further questions, the Commonwealth would rest on its brief.